Welcome back to the Critical Compass. My name is Mike, and this is my co-host James, and we are very pleased to be finally joined by Mr. Keith Wilson. He's a constitutional lawyer here in Alberta, well known for his involvement in the Freedom Convoy, other issues regarding Alberta independence. Currently, he's a strong advocate for, and that's why he joins us here today. We've had Mr. Wilson. We've had quite an eventful 48 hours here, haven't we?
We sure have. As many of your viewers will know that have heard by now that the Smith government introduced this past week Bill 14, and I'd be happy to explain to you what that means and where that puts us for those who are seeking Alberta independence. And then we've also had Justice Feasby release his decision immediately after Bill 14 was introduced, which is a pretty controversial decision. And I'd be happy to break down what that means and what it doesn't mean.
Yeah, please. Feel free to expound. Take your time. Let maybe start with Bill 14, just introduced yesterday, and what that means in respect to what we just saw announced today.
Sure. So, and let's start with some really basic building blocks to help people understand how the pieces fit together and what parts are moving and which parts aren't. So, as I've explained many times in different podcasts and on at podiums, is that Canada is a really unique democracy compared to other democracies around the world. It's unique in that Canada is just about the only democracy where our highest court, the Supreme Court of Canada, has said in the 1998 Quebec reference case that if the majority of the citizens of a province hold a province-wide, or if there's a province-wide referendum and the majority of the citizens vote on a clear question to become independent, to become their own country, to leave Canada, that they can do it. Okay, so that's pretty remarkable. Well, in Alberta, we have a referendum statute that allows the provincial government to call a referendum on a whole broad range of issues. You might remember that Jason Kenney, when he was premier, held a referendum on equalization and on daylight savings time. Okay, so the Alberta government can at any time that it wants call a province-wide referendum and set the question that will be put to the vote on independence. But we have another layer, an expansion of democratic principles in Alberta, where we have this statute called the Citizen Initiative Act. And that's where the Alberta government, and this predates Premier Smith, the statute says, among other things, that if a group of citizens come together and they want to force the Alberta government to hold a referendum, those citizens can apply to start a petition, a formal legal petition, not the one the guy signing come to your door to stop the community dump or, whatever, a real legally defined petition. And if in Alberta, if over 177,000 Albertans over 120 days, they get enough of those signatures, if they hit that threshold, then that forces the Alberta government to hold a referendum, in this case on independence. Unfortunately, legislation evolves, statutes evolve, and they get amended and they get changed and they get amended, and that's normal. And a number of years ago, there was an amendment to the Citizens Initiative Act that was dealing with some unrelated issue, and they had some wording in it, and the legislature changed it, but they left a little clause in section 2 sub 4. And the clause in 2 sub 4 says something along the lines of, a petition question can't contravene the Charter of Rights and Freedoms and certain constitutional principles. Well, that doesn't make sense in its own right, because it's not until there's a referendum and there's a negotiation with the other provinces after successful referendum that Alberta can become independent anyway, but that wording's there. So when the Alberta Prosperity Project in the summer filed its application for a petition for a referendum question on independence, the chief electoral officer said, I'm going to use this old goofy section and I'm going to send it to the courts and have the Court of King's Bench decide whether or not this question that APP is putting to the petition, whether it violates the charter and these other things, contravenes it. So that course case started, and you guys have probably covered stuff on that, and there's a wide awareness of it. And Jeff Rath and Eva Chipiuk, my colleagues, have been on their feet arguing that case and writing the briefs, and I've been helping in the background. So Justice Feasby is the judge who's had that case, and it's bogging the whole process down. You know, the Thomas Lukasik had his stay in Canada petition goes through smoothly. The Chief Electoral Office, red carpet treatment, come on in, get her done. Independence guys show up, all of a sudden it's legal trickery and legal this and legal that. So
I wanted to ask you on that specifically, so it seems like this Citizen Initiative Act, that Section 2.4, it's right now is dealing with the hypothetical that the result of a referendum might contravene, because they went down all these paths. They said, well, might do this, might do that, might do that. But technically with the Forever Canada question, the no result from that has the same hypotheticals. So why wouldn't that be subject to the same sort of process in court to deal with those hypotheticals of a no vote on the Forever Canada's referendum question?
Well, and your question and you're pointing out that contradiction illustrates how defective that section is, right? Like, is there a double standard, or is the chief electoral officer abusing his discretion, right? Like, which is it? Either way, it's a problem. And so, and one of the details I may not have mentioned is that, just going back to basic principles, is what the Supreme Court of Canada said is that in the 1998 reference case, is that where a province holds a province-wide referendum and a clear majority vote in favor of independence, that triggers a positive legal duty on all the provinces, the federal government, and the First Nations to sit down and have good faith negotiations and agree on what the independent country will look like and what rights will carry forward and which ones won't. Okay? So there's a mechanism built in our constitutional framework to deal with that thing. Why would you deal with it hypothetically way, way, way at the start of the process when the group requesting the petition may not get the signatures? And if they do get the signatures and force the referendum, it may not pass, right? It just seems nonsensical to empower the courts to intervene and thwart the political will and the democratic process. So the Alberta legislature and the Smith government watching what's going on, and this week they finally said enough. It's their job as the lawmakers, as the legislature, to clarify when and take steps when their legal intentions are being misunderstood. Canada is a parliamentary democracy. And what a parliamentary democracy means, we have a principle of parliamentary supremacy. And parliament means the legislature, whether it's the federal House of Commons or whether it's a provincial legislature. So we have legislative supremacy with the elected officials. That makes sense. Who do you want making the laws? The people you elect. That way, if there's bad laws, you can fire the people that made them at the next election, and you can replace them with people who share your values and make laws that are reflective of your society and your community and your culture and what your aspirations are. So it's a fundamental principle that we have the principle of parliamentary supremacy. So that means at any time, the legislature can make new laws At any time, they can amend existing laws and they can repeal existing laws. And that happens all the time. When the NDP got into power, they changed a whole bunch of laws the Conservatives had. And before them, the Conservatives changed a whole bunch of laws that the Social Credit government had. And before them, you know what I'm saying? So this is normal. This is how democracy works. So the principle of parliamentary supremacy is that the legislature makes the laws, they can amend laws, and they can even do it retroactively. They can retroactively change law. Happens actually quite a bit. A lot of people don't realize that. The court's job is to interpret the law, not to make it. Okay? So the legislature was watching what was happening, and they said, our intention for the Citizen Initiative Act is not being achieved. This is not what we intended. And when they discover that, the proper thing for them to do, and arguably they have an obligation to do, is to clarify the law. And that's what they're doing through Bill 14. They never intended this wording to have this effect. They never intended this to get bogged down in the courts. So Bill 14 says this section's gone. That reconciliation of how the constitutional rights and charter rights work will be dealt way down the road after the referendum in the negotiations with the other provinces. And they've said, with all due respect, Justice Feasby, close the case. This is not something that should have ever been opened. We are taking your jurisdiction away. We never intended this to be a decision of the courts. This was to be a democratic decision of people, of citizens coming together. That's why they call it the Citizens Initiative Act, right? Citizens. It doesn't say the Judges Initiative Act, right? So the idea is that the legislature's now acted to achieve the original legislative intention. So what will happen next is the Alberta Prosperity Project will have 30 days to reapply, submit their question again, or change it if they want. And then the Chief Electoral Office have 30 days to review and approve it and authorize the forms and the specific petition forms. It has to be an official form coming from Elections Alberta. Validate the canvassers, all these things. Not just anybody can sign up at your door with any piece of paper. Make sure you only sign an official petition. And then the Alberta Prosperity Project will have 120 days going into next year to collect the 177,000 signatures. And then once those are filed and validated, then it will be incumbent upon the Smith government to, in the fall, I suspect October, to hold a province-wide referendum on independence. So that's what's coming. And this major obstacle, this major distraction, this major waste of time, this undemocratic thing that's been occurring of judicial intervention will have been remedied. Now, okay, great. Well, Justice Feasby actually released a decision today. It's remarkable.
Interesting.
And it's a long decision.
Was that
and
planned
it reads
today?
What?
Or was that, did they schedule that?
He was still supposed to be receiving submissions today.
That's what I thought. I thought,
like, what's going on here? He had it in the can. He was receiving submissions today, and then he rendered, I think, don't quote me on this, but I think it's 176 pages. It's long. It's long. It's in that order of magnitude if it's not 176. It's just under 200 and it's more than 150. It's a big decision. Now, he goes into all this hypothetical analysis and this political stuff about treaties and treaty rights that he has to use his imagination to concoct a breach of, because no one's put a proposal to the First Nations, and the First Nations haven't been asked to express a view on the proposal. It could very well be that one of the outcomes of an independence vote and the negotiation with the federal and First Nations is that Alberta, the new Alberta government for the new country of Alberta, says, First Nations, your lands will continue to be reserve lands in Alberta. It's less than 1% of our land base, no big deal. You will continue to be administered by the federal government in Ottawa, their government, the Canadian government. You will continue to have your treaties administered by the government of Canada. Nothing will change. You'll be Canadian citizens with First Native status, and you will leave your reserve and go into the province or the country of Alberta. And we don't need borders because you don't have landing strips. So just have at her. So it's not
And
even
that
the
would be
case
the
that
bare
anything's going to
minimum.
change. So
Yeah.
I was really surprised and disappointed at Justice Feasby's actions. I think they're inconsistent with the rule of law. I say that with the greatest of respect. And there was this whole political overtone when you get a chance to read it. And it's very shocking to me that the judge would have done this. I think the proper step for the court, because I've encountered this before where I've had cases before the courts and the law changed in real time, right? I remember one, I was getting ready in the morning. This is pre-COVID, precedent-setting case for right to farm laws in central Alberta. And just for some reason, I was doing my final prep early in the morning, reading my briefs, just ready to head out the door to head down to the courthouse. And I got a blip on my screen, a notification the Supreme Court of Canada had just released a decision. And I thought, I clicked on it. The Supreme Court of Canada completely changed the entire body of law that applied to my case. And so I phoned the other lawyers, like, holy smokes, all of our work down the drain. So we went and appeared before the judge, senior judge of the court, and said, well, and he was like, wow. And we all joked it because it was a long decision. None of us had even had a chance to read the thing, but we all agreed that we had to start over because the legal framework had completely changed. So this happens. Doesn't happen every day, but this is a normal occurrence in our legal system. So what Justice Feasby, in my view, should have said is like, look, this act is changing the law. It's changing it retroactively, and it's saying this case needs to be concluded because the legislature believes it's inconsistent with its legislative intention, and it has supremacy. I am just a judge. I just apply the law and interpret it. The legislature makes it. So I'm going to adjourn this hearing, and once the legislature proclaims in a couple of weeks it into law, I will be dismissing this case because I have no jurisdiction to deal with it. Okay, that should have been what happened. But instead, he was furious. Apparently, I was not in the courtroom, but I heard that from the lawyers that were. And he added something and went into a tirade about the government. I'm very disappointed in that. Here's the good news. It has no impact, none, on the ability of the Alberta government to hold a referendum on independence. It in no way changes the rules around an independence vote by the provincial government. It no way changes what happens after that, as has been directed by the Supreme Court of Canada in the 1998 reference case, which is if there's a successful vote in Alberta, clear majority in favor of independence on a clear question, then the provincial governments, the First Nations, and the federal government are all required to enter into good faith negotiations as to the terms of Alberta becoming a free and independent country. So it has no impact on that. And because Bill 14 amends and takes out those mischief words, it also has no impact on the process going forward for the Alberta Prosperity Project and the Chief Electoral Officer and the election and the petition drive and the validation process for that petition.
Okay, well that's really good news then. So, regardless of the, we can speculate on the judge's motivations and kind of what you said there about his demeanor in the courtroom is pretty telling. That's actually fairly shocking to hear. But is it then? I don't know if you're able to say this or not, but would it be your legal opinion that once Bill 14 is passed in the legislature, does that render this ruling moot, or does it have any stickiness after the fact?
I don't even know if it makes it moot. I mean, it makes it moot, but he should have never rendered it in the first place. That's what's so strange.
It's confusing,
but he's
right?
opining, it'd be like me, offering opinion on this coffee cup and writing a manual about it, and then this coffee cup no longer existing. So it's like,
and then you drop it on the ground.
Great, you got your manual, but there's no coffee cup anymore, so don't need the manual.
Yeah.
So it's and that's why it looks like it reeks of being a political exercise, which I was very surprised at. And that's one of the things that I don't know. I haven't seen an opinion poll, but if I had to guess, I'd suspect that confidence of Canadians and Albertans in particular in our justice system is at a very low point, and maybe all-time low. I don't know, but it's at a low point. we've all seen the two-tier justice stuff. If you're an immigrant and you do some violent crime, the judge is all worried about your immigration status. And but if you're Tamara Leach and you embarrass the prime minister up trying to fight for charter rights and the rights of unvaccinated Canadians who've having their rights violated, you get convictions and almost 2 years of house arrest. And in addition to the 49 days that they put her in jail and the 10 days in solitary confinement. We all have seen this two-tier justice system. It's so strange. If you're a law-abiding gun owner, you're a terrible human being. But if you're a criminal in Toronto with a legal handgun smuggled in from the U.S. into a smash and grab, we're supposed to feel sorry for you. It's just so weird.
Yeah, well, they're victims, you see,
We've
right?
all seen this two-tier justice. So justice is supposed to be blind. Lady Justice is supposed to have a blindfold on. And we've seen remarkably in Canada that Lady Justice doesn't have a blindfold on anymore. And it seems to be more related to whatever political group or category you're slotted into. So I'm really hopeful that in time, the courts will get back to being blindfolded and not judge people by their politics and not seek to be political actors, but just administrators and interpreters of the law. And today wasn't that day.
So my one question with this is even though Feesby's decision does not have any legal weight now, I think it still has some political weight because it will be used by those who are uninformed or who don't fully understand the situation. They'll point to it and saying, well, this is why the APP's whole petition is invalid, and they'll use that as ammo to smear or dismiss. And I think if you wanted to try to give ammo to the other side, Feesby did pretty much everything that he could to try to tank any future movement or any future petition with this.
And I think it'll be worse than that, James, because I don't think they'll even be that nuanced in their attacks. I think people who are opposed to this, to independence, will cherry pick from that decision and use it as an argument as to why Alberta can't become independent.
Yeah.
Like they'll move it, they'll inflate it. They'll conflate independence vote with the process for a citizens initiative petition, and they'll create confusion. I've spent the last year and a half trying to get people to understand really basic things. Like somebody will say, well, Alberta can't separate because all of the crown land in Alberta is owned by the federal government. It's like, actually, no, it's a tiny, tiny percent. There's a provincial crown and a federal crown. People think crown means federal. No, it doesn't. You can't leave well, you can leave, but we're keeping the oil and gas. Well, good luck for that. You might need to read the 1930 Natural Resources Transfer Agreement, which is a constitutional document that transfers ownership and control of all of the unoccupied land. So all of the land in Alberta, and the water and the oil and gas and minerals from the federal crown to the provincial crown, both in Alberta and Saskatchewan. So there's just so much misunderstanding about basic civics and basic how our political system works today and is structured and legally constitutionally allocated, that that lack of understanding combined with people's emotional political agendas, they'll take clauses from this agreement, from this decision, and create all kinds of confusion. Yeah. But we anticipated this, right?
Yeah.
Like anybody who had this discussion. I was just did an interview today with Rebel News with Ezra Levant. And Ezra's like, this is an illustration of how they're going to use lawfare and all these things. Well, I think I've had 3 interviews with Ezra over the last year. And in the very first one, him and I talked about how the closer Alberta gets to seeming to be independence, the more the attacks are going to come, the more the legal challenges are going to come, the more the interventions are going to come, more smear campaigns, all those sorts of things. And that's where we're at.
Yeah, that's a huge thing that James and I have identified in a few of our interviews, that it's going to be a gigantic hurdle to overcome for even for people who are pro-independence. They still, might have a bit of a underlying kind of defeatist attitude about it, because it seems like such a lofty goal and a huge task and such a big undertaking. But especially for those who are on maybe the opposite, this really shouldn't be a left-right issue, but it kind of is. Do you, Keith, have sort of maybe an elevator pitch that you've been working on, or that you've, because you've said it so many times, that you would say to somebody somebody maybe on the leftmost side of the political spectrum who's very, very against the notion of Alberta independence, why it would actually even be better for them?
I would say that the reality of the structure of Canada in terms of who gets to make the policies and laws in Canada is skewed, and there will never be a time, nor has there been a time, where Albertans have a voice in that process. And so if you want to live in a place where your voice matters, regardless of what that voice might be, you're going to be better off. You're going to have more democratic power by being in an independent Alberta. And in addition to that, you're going to be more prosperous, because what you can do is look at your paycheck, look at the pay stub when you get your notification of your pay, and look at your gross pay and look at your net pay. Imagine if you got your gross pay. In other words, you got paid for the labor that you expended, the value you provided to your employer. Saudi Arabia, which demographics aren't as favorable as ours, they pay no income tax. Any country in the world that has the resource wealth that Alberta has, their citizens don't pay income tax. They don't pay for healthcare. They have state-of-the-art quality services. And we could have those things here through an independent Alberta in spades. Those are facts. Those aren't guesses. Those aren't aspirations. That's the reality that it would be and will be when Alberta is free and independent.
Well, I think that's a fantastic way to close, sir. We've had you about for the amount of time I think we can today. So super appreciate you taking the time to explain the nuances of this really big couple days in Alberta politics. Before we let you go, do you have any speaking engagements? Do you have anything coming up that you want people to know about that they can look into?
Sure. Because of the need to get accurate, authoritative information out as we engage in a further information warfare process that's going to become increasingly from the federal government and those on the left, I've just actually have set up a new YouTube channel where I'll be providing updates on things, and you'll be able to find that under Keith Wilson KC. It stands for King's Counsel. It's my legal designation. Or my Twitter handle, you can similarly search it, which is at IK Wilson. So I will, but I'd like to come back on your show as well and have a broader discussion about some of the other things we haven't had a chance to talk about today, because I've been meaning to do that for quite some time. And but there was such breaking news here that's so important and sort of complex and confusing. I was really grateful that you guys adjusted your schedule to have me on.
Oh, hey, our pleasure, and absolutely, you will be back, sir, whenever we can make it work. Thank you very much for this.
Thank you.
It's great to have you on.